Okay. Use only leading questions. All right, this is probably the most controversial of Professor Younger's 10 Commandments, and it's usually true. I would say that if you're under 5 years out of law school or you have fewer than 5 trials, you probably should only use leading questions. Non-leading questions on cross should probably be reserved for more experienced trial lawyers. Okay, it's dangerous, all right, to do it, but it can be done. All right, and let me give you a couple of examples. All right, both of them from DUI trials. Okay, one on the prosecution side, one on the defense side. By the way, DUI trials, don't look down your nose at DUI or traffic. It's really a very niche area of law. Some of the best trials and best trial lawyers I've ever seen have been in DUI trials. But both of these, the best crosses I saw on the bench happen to be in DUI trials. So on the prosecution side, the defendant had a Polish interpreter. All right. So on direct, the defense lawyer elicited testimony that the defendant that his client was a truck driver with a commercial driver's license, but he did not speak English, so therefore he could not understand the police officer's instructions on how to perform the field sobriety tests, which were very important and a critical part of the state's case. And if he didn't understand how to perform the field sobriety tests, that's why he didn't perform them well. That was the defense. Okay, so. The state's attorney, who was a very experienced guy named Bill Gorey, an excellent experienced prosecutor who had a civil background too, by the way. He did some personal injury work, plaintiff's personal injury work. So here's a portion of his cross. And I wish I had gotten a transcript of these crosses. I wish I had thought of it at the time because they're great teaching tools. So this is from memory, but this is how significant these crosses were in my mind that I'm able to, I think, pretty much recreate them from memory. So, prosecutor, the defendant, crossing the defendant. You're using a Polish interpreter, right? The defendant through the Polish interpreter, yes. So you speak only Polish. Defendant, yes, with very limited English. But you have a commercial driver's license, right? Yes. And you had to take a test to get your commercial driver's license, right? Yes. And that test was in English, right? Yes. But you don't speak English, right? Objection. Overruled. Right, only limited English. And if you don't speak English, you don't read or write English either, right? Right. So how did you take and pass the test? Okay, non-leading question. Okay, dangerous. How did you take and pass the test? And the reason this experienced prosecutor was able to ask that because he knew that either the answer didn't matter or that he knew that he was going to be able to trap the defendant with whatever answer he gave. So the defendant goes, and this was what was dangerous about it. I had a friend translate the practice exams for me, and I memorized the answers. Okay, that was his answer. Potentially dangerous answer if pigs flew, and I had any possibility of actually believing that. And at this point, I was starting to become a little skeptical of the defendant's testimony. Prosecutor, you memorized the answers? Yes. You memorized them in exact order? Yes. And the answers on the actual exam were the same and in the exact orders, and the exact order as the answers on the practice exam? Yes. Okay. At this point, the defendant's credibility was completely destroyed, and I felt eminently comfortable in finding this defendant guilty beyond a reasonable doubt. When a defendant is proved to have lied on the stand, in my mind, that's guilt beyond a reasonable doubt. So that was a slam dunk, I think, for the prosecutor. Here's a slam dunk for the defense on the other side. So this is a trial in a breathalyzer case, okay, where the defendant blew. It's called an A1, subsection A1 of the DUI statute. And usually in these breathalyzer cases, by the way, they're almost always pleas. They very rarely go to trial because the breathalyzer is usually enough evidence to convict, to show proof beyond a reasonable doubt. Okay, so this is a rare situation with a very good lawyer, a very good defense lawyer named David Mejia. So good, he's actually represented some judges in DUI cases and former judges for that matter. Excellent lawyer. So in the breathalyzer case, the defense. Mr. Mejia's defense was that the cop did not wait the obligatory 20-minute observation period before administering the breathalyzer to the defendant. Okay, in every DUI case, in every breathalyzer case, the police officer is required to have a 20-minute observation period to make sure that the defendant doesn't throw up, doesn't seize, doesn't do anything. Anyway, there's a 20-minute observation period that's absolutely required. So that was his defense, that he didn't wait the 20 minutes. So the amount of time is highly relevant to the defense, and Mr. Mejia's cross had to do with what's called the warnings to motorist, which is also required reading for a cop to the defendant. The cop has to read these warnings to motorists to warn the defendant of the consequences of refusing the breathalyzer test or not refusing the breathalyzer test. Okay, so that's part of the that's part of the requirement, just like the 20-minute observation period. So. Mejia, how long did it take you to read the warnings to motorists? Okay, another non-leading question that paid off in the end, although I think Mejia knew what the cop was going to say based on his past experiences, but a risky question, depending on what the cop said. The cop goes about a minute. Okay, Mr. Mejia calls his bluff. Okay, read it. State, objection, ruling, overruled. Goes to the length of the 20-minute observation period. How long it took him to read the warnings to motorists is relevant to the 20-minute observation period. So the cop reads the warning to motorists as I'm timing it on the courtroom clock. It has a second hand and everything. I'm watching it. I can still remember in my mind's eye watching it. The cop reads it all the way through at a reasonable pace. It takes 2 minutes and 25 seconds for the cop to finish reading the warnings to motorists. Okay, so if it had been a minute and 15 seconds, maybe a minute and a half, I would have given the cop a break. It was an approximation, about a minute, but this was 2.5 times what he estimated. Okay, and that in my mind was highly impeaching of the police officer's testimony. His credibility was completely destroyed, and based on that cross-examination, it directed a finding in favor of the defense. Defense didn't even have to put a case on. Case over. The cop's credibility on the 20-minute observation period was completely destroyed, and as rare as it is for a breathalyzer case to go to trial, even rarer probably that the defense wins it. But he obviously had a defense, a good defense, and a good cross. So those are two of the examples of the probably the two best crosses I saw as a judge. Frankly, most other crosses, repetitive and boring. A lot of them involved repeating the testimony on direct examination. For what reason? I don't know. Maybe to get them into a yes pattern. The idea you want to get the witness into a yes pattern so they start agreeing with you like a trained seal to everything you're going to ask. Or to possibly elicit testimony to emphasize testimony that they thought was helpful to their defense, bless you, was helpful to their defense, not. It was already out on direct. If it's helpful to the defense, you can argue it in summation. It's evidence. You said it as a defendant and as the witness testified on direct, Why re-elicit it on cross unless it really helps the defense? And I saw an awful lot of that on the bench. So, that's part of being brief too. Repeating the questions on direct in hopes that you're going to get a different answer, or that it somehow helps your defense, and that the other side was mistaken in eliciting it on direct. Not a good strategy. You should definitely ask some questions, some setup questions, and try to get them in a yes pattern, but don't repeat the entire direct examination or half of it. Okay, that was commandment number 3.